Another example is Utah's HB273 that was passed in this last legislative session, which enables reverse keyword search, including warrantless search and bootstrapping of special warrants using general warrants. Well, I have to break it to you, but there is no such thing as a general warrant. And it's because of this language in the Fourth Amendment right here that they have to particularly describe the place to be searched and the persons or things to be seized. Meaning, the officers of government have to already have a probable cause of a known observed crime before they can go and root through your stuff. They can't just assume that a crime happened or hold their breath and wish that a crime happened so they can catch you with something. They have to actually have public knowledge already to then further to support that issuance of a specialized warrant. There's no such thing as a general warrant. And this bill, HB273, very perniciously, it leverages what are called general warrants to bootstrap the issuance of special warrants. In other words, they can just type in search terms into the computer and find everybody who used those search terms on a computer, like ever, and then use that information to say, well, in our subjective opinion, these search terms might be connected with such and such a crime that we have no evidence, by the way, actually occurred, right? And so it violates the probable cause, violates reasonableness, and it doesn't particularly describe anything. It's just saying, we're just doing a dragnet search just to see, just in case, just to snoop on you, and then see if we can kind of torture this to see if we can make a crime appear out of this. And then they go to a judge and then get a special warrant that says, well, based on this already illegally obtained information, we're going to use that to bootstrap the issuance of a special warrant. And the bill also contains wording that allows them to have a loophole outside of that as well, because there are various types of crimes that are specified in there that ostensibly qualify for an exemption to where they don't even need a warrant, period. And this includes, by the way, like a federal database of alleged child predators, terrorists, and stuff like that. So basically, if the partisan regime in government right now puts you on a watch list for whatever reason or no reason at all, then the state has granted to itself the power to greenlight and just search any of your digital belongings, possessions, anything without a warrant, and just, hope they turn something up so that they can then try to slap some kind of crime on you. And this is totally unconstitutional. It's extremely invasive. You don't have security in your person, in your house, in your papers, effects against unreasonable searches and seizures as long as the government arrogates to itself the ability to do these things. And I've talked with the with several of the legislators about this bill, and they claimed that they saw nothing wrong with it. And so, like, we've got major gaslighting going on here. Like, you can read the text of the bill, and it clearly says, we're not going to require a warrant in cases X, Y, and Z, and we're going to issue general warrants in these cases. And you look at the Fourth Amendment, and the Utah Constitution mimics that language. There's no such thing as a general warrant. It's a legal fiction that was invented by these guys so they can steal your information without probable cause, without oath or affirmation, without a warrant, and then go and use that to bootstrap the issuance of a special warrant. So this is one of the ways that they are stealing your information to try to hallucinate a crime.